How to draft wills and trusts. Are you curious about how to draft wills and trusts? This is a vital skill in estate planning and a key topic in law school. Let's break down the steps to help you master this process. First, it is essential to understand the basic concepts. A will is a legal document that outlines how a person's property should be handled after their death. It appoints executors and beneficiaries and may include guardianship for minors. A trust, on the other hand, is a fiduciary arrangement where one party holds property for the benefit of another. Trusts can be revocable or irrevocable and serve various purposes, such as estate tax planning. Before you start drafting, gather all necessary client information. This includes identifying the client's assets, family situation, and goals. Next, clarify who will receive assets and who will manage the estate or trust. It is also important to review relevant laws in your jurisdiction. Each state has specific requirements for wills and trusts, including execution formalities. When drafting a will, start with a clear title, such as Last Will and Testament. Include a declaration that states the testator's identity and intent. Make sure to add a revocation clause to void any prior wills. Appoint an executor who will be responsible for administering the estate. Clearly specify gifts to beneficiaries, including specific bequests and residuary clauses for the remainder of the estate. If there are minor children, appoint guardians as needed. Don't forget to include an execution clause confirming that the will is signed voluntarily and witnessed according to legal requirements. Finally, ensure the will is signed by the testator and witnessed by the required number of competent witnesses. For drafting a trust, begin with a title and declaration of trust. Identify the settlor, trustee, and beneficiaries. Describe the property being placed in trust and specify the terms and conditions, including the trustee's powers and duties. State how long the trust will last and under what conditions it may be terminated. Clarify whether the trust is revocable or irrevocable and specify which jurisdictions' laws govern the trust. While drafting, clarity and precision are key. Use clear language to reduce the risk of disputes. Ensure consistency in terms throughout the document. Always adhere to statutory requirements for execution, such as witness presence. Anticipate contingencies by including provisions for alternate beneficiaries and unforeseen circumstances. After drafting, carefully review your work to correct any errors and ensure it aligns with client instructions. In law school, practical applications are vital. Analyze sample documents to understand their structure and language. Engage in drafting exercises based on hypothetical client scenarios. It is also beneficial to learn how improper drafting can lead to disputes and how courts interpret wills and trusts. Incorporate estate planning principles to see how wills and trusts fit into broader strategies. By mastering these steps, you will develop the skills needed to draft effective wills and trusts that meet legal requirements and reflected your client's intentions. This foundation is essential for future practice in probate, estate planning, and trust administration.